So how do red flag laws really work? Well, I'm going to tell you. But before we get to that, if you think red flag laws are a violation of your Second Amendment and your due process rights, please like and subscribe. Good afternoon and welcome to Lawyered Up. I'm Patrick McGee. I'm a Florida trial attorney and former police officer, and I try to bring you news and information about firearms in the legal field from across Florida and across the country. So how do red flag laws really work? Well, you see a lot of videos on YouTube, especially on gun channels, about red flag laws. They give a basic description of them and how they work. It's different for every state. I'm going to tell you, as somebody who practices in that area, how they work in the state of Florida. In Florida, the technical name for the red flag laws is risk protection orders. It's in the crimes chapter or Florida statutes under 790, weapons and firearms. And it allows any law enforcement agency or law enforcement officer to file a petition for a risk protection order. So what does that mean? Well, in the big counties, I'm not sure about the little counties, but I practice in South Florida and it's the big counties. The law enforcement agencies file them, not the individual officers. And the law enforcement agencies employ attorneys, either their own attorneys or they contract with outside counsel to file these. So in these counties, you're almost always going to be going up against an attorney. Also under Florida law, the standard's a little bit different. You have three standards in law. You have a preponderance of evidence, which is the lowest standard, which is 51% and you win. You have clear and convincing evidence, which is the intermediate standard. And then you have beyond a reasonable doubt, which is the criminal standard. So our risk protection orders or red flag laws fall under the clear and convincing. So a judge has to find that there's clear and convincing evidence that a person who is the respondent in one of these cases poses a significant danger of causing personal injury to himself, to others, by having a firearm or ammunition in his possession or control or custody, or by purchasing, possessing, or receiving a firearm or any ammunition. So that's what the judge has to find by the clear and convincing evidence when they have the hearing on this. So how do these cases get kicked off? Well, the police department or the law enforcement agency files the petition with the court. They send it over to the judge's secretary. A judge will review the petition and can hold a hearing, what's called an ex parte hearing. A lot of people call this a secret hearing, but it's not a secret hearing. It's actually a public hearing, and the public can be present at it. It may be a secret hearing for you because you're the only one, if you're the respondent, you're not going to know about it. So the judge holds this hearing. It can either be in person or by telephone. And if during this hearing the judge determines that there is reasonable cause to find that the respondent is a danger to himself or others by possessing a firearm or ammunition, the judge can enter an ex parte order. So an ex parte order is a one-sided order because it came from a one-sided hearing. You don't have anything to say in this hearing because chances are you didn't know about the hearing to begin with. They don't have to present any evidence favorable to the respondent at all. So if a judge enters this ex parte order, it gets transmitted back to the law enforcement agency for service along with a notice of hearing for the permanent injunction, which can last up to 12 months. So that hearing on the injunction has to be held within 14 days. So you may not get it on that same day. You may get it the next day and you only have 13 days, or you may get it the day after that and you may only have 12 days. But they will come out and they will serve that ex parte order, which will have which basically contains a court order for you to surrender all firearms to the law enforcement agency. Now, specific to the statute is a provision that attorney's fees cannot be had. So you can go through all this rigmarole, be drugged through this whole hearing, have to pay attorney's fees and whatever other costs, and you cannot go after the petitioner, the law enforcement agency, or anybody else involved for attorney's fees. That's specific in the statute. And there's no age requirement. You don't have to be any age. They file these against kids all the time. And you don't have to be a firearms owner. Nothing in the statute says you actually have to own a firearm. That is one of the things that the judge can consider. One of the factors the judge considers whether you recently purchased a firearm and ammunition or you made a threat with a firearm and ammunition, but it doesn't have to involve firearms. You don't have to be a firearms owner. The allegations do not have to include threats with a firearm. They can just include threats of violence and other ways. So they file these all the time against non-firearms owners, against juveniles, against anybody who they think that they can be successful on. And there's a long list of factors that the judge can consider, but basically it comes down to what the last factor is, which is any relevant factor. So the judge can, in the hearing, can consider any relevant factor. So you have this hearing coming up in 14 days. What do? There's two things you can do. You can go to the hearing and go for broke and try your best, but I'm telling you, according to the statistics on these cases, most people show up to these hearings unrepresented. They end up getting a risk protection order entered against them, and it's valid for 12 months, and it can be extended after the 12 months. The other option is you can hire an attorney and actually prepare for the case, or actually anywhere in between. You can hire an attorney and just show up at the hearing and do the best you can and see what happens. The statistics show in Florida, when a party is represented, when a respondent is represented by an attorney, they do significantly better. They win a lot more of the cases. So what do you have to do to prepare for one of these cases? Well, the way I prepare for these cases is I go all out. The problem with that is, and the problem with engaging an attorney in that time period and for the attorney to do his full investigation to properly represent you, most likely they're not going to be able to get that done within 14 days. And this is where it really messes you up. So I usually tell my clients straight up, we're probably not going to get this done within the 14 days or however many days. It's probably usually around 10 days by the time it gets to me. We're not going to be able to get this done in time because we're going to have to interview the officer, do depositions, interview any witnesses, send the person out for a psych eval, and the whole 9 yards. And you can't do that really in a 14-day period. It certainly can't do it in a 10-day period. So you end up getting jerked around for this for longer. You end up having to request a continuation of the hearing. So although one of the main aspects that they promote on these cases, hey, you get a hearing within 14 days. But what they don't tell you is you really can't be ready for that hearing in 14 days because you have a lot of preparation to do because there's a lot at risk here. You're risking a constitutional right. So what happens is to a lot of people is the same thing that happens in domestic violence injunctions. They think if they just go in, they're convinced that their side of the story is a winner story. They go in and tell the judge is going to side with them. And then 95, 97% of them get the risk protection order entered against them, and then they want to call me for me to help them on the case. But once it's been entered, it's very difficult. Once these injunctions go in place in a permanent status, or in this case a 12-month status, they're very, very difficult to get reversed. You can file a motion to vacate them, and then the burden shifts back to you. You have to prove by a clear and convincing evidence that you are no longer a threat to yourself or a danger to yourself or somebody else by owning or possessing a firearm or ammunition. So now it becomes a big mountain to climb. It's a very much more difficult case. So these cases, if the risk protection order is entered, it's good for 12 months. Anytime during that 12 months, you can move to vacate it under that pretense. At the 12-month period, it's reviewed again. You have another hearing again, another opportunity, and the judge can choose once again to extend it if they still find that it's necessary in the case under the guidelines and under the elements that we previously discussed. So when they come out to serve you with this temporary risk protection order and the notice of hearing, they're going to do a couple things. They're going to seize any firearms or ammunition that you have in your possession because they have a court order that says they can. And they're also going to seize your concealed weapons permit if you have one. And it's going to go to the state of Florida Department of Agriculture, and they're probably going to revoke or cancel it or put that into some type of suspended state. What a lot of people also don't know about these orders is there's a provision in the order for third-party transfer. Once law enforcement has impounded the weapons and the firearms and the ammunition, you can petition the court to have it released to a third party. And that's a whole nother hearing and rigmarole that you have to go through. You have to have another hearing and present evidence of this third party. The third party has to come in. But that is an option in these particular cases. I don't see that a lot. I see people basically at these hearings, when you sit through them and you watch the hearings come up, a lot of people just give up and go, yeah, okay. But if you own like a large firearms collection, when the police come in and pound these weapons, they're not bagging them, boxing them, and taking care of them. They're throwing them in a garbage bag or in a box, one on top of the other, taking them in the trunk of the police car to the police station. They're going to take it to the firearms section so they can all be test fired and compared against any outstanding cases or anything like that. So they're going to be handled, they're going to be shot, they're going to be banged around. When you get them back, if you get them back, I guarantee you they're going to be in a much poorer condition than when they left your safe. Anyway, so that's the risk you take in the different ways you can handle these types of cases. Like I said, a lot of people just go in, especially people that don't own guns, and a lot of the kids and stuff, their parents go in with them, and they just give in. But if you have a significant collection, it may be beneficial to fight this all the way, and that can be very expensive because you have the attorney's fees, so that's going to be several $1,000s. You have deposition expenses if you take depositions of the police officer and the witnesses. That's going to be, anywhere between 500 and 1,000, maybe 1,500 per deposition. You're going to have a psych eval, which it runs anywhere 2,000, 2,500. I've seen as far as 3,000, 4,000. And then you're going to have to pay whatever doctor that does the psych eval to come in and testify at, 200 to 500, maybe $600 an hour. So the battle is expensive, and you go through all that. But since the statute says that you can't get attorney's fees, even if you win, you're out that money. Anyway, that's how risk protection orders, red flag laws work in the state of Florida. Got it from somebody who actually practices in that area. I'm in that court all the time, so I see it, and it's crazy how they go. Some counties use it a lot. South Florida counties use them a lot. Some of the other counties not so much. And then there's several really small counties that I've never heard of any risk protection orders being filed in those counties whatsoever. But if you become subject of a risk protection order, whether it's temporary or if it's just a petition that's been filed, immediately seek counsel. That's your tip for the day. Thanks for joining us here at Lawyered Up and listening to topics that I'm passionate about. I hate these cases. I hate that this statute is in place in the state of Florida. I think it's unconstitutional. I think it'll be challenged. Certainly, if we get a case on board that's challengeable, we'll definitely challenge it. And I think in the end, we'll get them knocked out under the Bruin decision, because there's absolutely no history of red flag laws until the last few years in the United States. Thanks a bunch for listening. Like and subscribe if you like this content. Share with your friends, and I'll see you next time on Lawyered Up.